Mr. Heinze. We're on for a number of motions. Judge Hollowell or Judge Kaltenbach set this court date for you to have your motions filed, and then he set a jury trial for April the 19th at 9 a.m.
Judge, may I have permission to turn my tablet on
To
get to my notes?
Sure. All right. Mr. Heinze, before we get started, I feel compelled to conduct a Faretta hearing. That's to determine that your waiver of counsel is knowingly, intelligently, and voluntarily made, sir.
I'm not waiving counsel.
So you're going to hire your own counsel?
Well, once again, I request the court to appoint one for me.
Since you do not face jail time, you're not entitled to a public defender. They're only for indigent clients that are facing jail time.
So as far as I understand, I mean, the federal courts would not frown upon an appointment of a free lawyer if this was appealed.
But Mr. Heinze, if you need an attorney for an appellate issue, that's totally separate. But the public defender's office, they have so many cases that it's difficult for them to manage their own cases right now. And adding a case in which you're not entitled to have, I'm not going to do that because you do not face jail time in this. If you get to a point where you are facing jail time, such as if you're found in contempt of something, I would appoint a public advocate of that at that time. But I'm going to ask you some questions before we proceed to this trial. So, are you a licensed attorney in Kentucky?
No, sir.
Have you ever studied law specifically in Kentucky?
Just since I was arrested on January 3rd.
But before that?
Nope.
Have you ever represented yourself or any other defendant in a criminal action?
For a short period of time, usually for motions. I'm trying to raise money up for a lawyer. I'm short. But through motions, I usually file them myself, and I will strongly look for a lawyer for trial because I am not skilled.
I assure you, we're going to just have this trial on April the 19th. So that's happening. You said it, so we're having it. Do you realize that you're charged with criminal trespass, 3rd degree, and if found guilty, you could be fined up to $100 plus court costs?
Yes, sir.
Do you realize that if you're found guilty and the jury recommends the maximum of a $100 fine, I'll follow that recommendation?
Yes, sir.
Do you realize that if you represent yourself, that you're on your own? I can't tell you how to try your case, and I can't advise you on any rules. You understand that?
I understand.
All right. Are you familiar with other than you looking them up for these motions, are you generally familiar with the Kentucky Rules of Evidence?
Generally, on a lower scale, somewhat aware of the Kentucky Rules of Criminal Procedure, the ones that are applicable.
Those are two different things: Kentucky Rules of Evidence and Kentucky Rules of Criminal Procedure.
Both. I have a little awareness of them, and I'm in the learning process.
Okay. So you have some awareness of the Kentucky Rules of Evidence and some awareness of the Kentucky Rules of Criminal Procedure.
Yes, Judge.
Do you realize that I will follow the Kentucky Rules of Evidence, and I will determine with those rules what may be and may not be introduced at trial, and that you're going to have to abide by those rules at the trial?
Yes, Judge.
You realize that I'm not going to cut you any slack. If you don't understand how to get a piece of evidence in that you want in, it's just not going to come in. You realize that?
Yes, Judge.
And the same with the Kentucky Criminal Procedure. I'm going to ensure that you abide by those. Do you understand that?
Yes, Judge.
Now, do you realize that if you decide to take the witness stand, you must present your evidence by asking yourself questions and then answering them? You can't just get up there and talk. Do you understand that?
Yes, Judge.
All right. In my opinion, you would be better off defended by a lawyer in a jury trial. You're going up against Mr. Newbern, presumably, that has guess, 20 or more years of trial experience, including training in death penalty cases. I've personally tried a number of cases against Mr. Newbern. I find him certainly to be a competent attorney with the appropriate knowledge of the rules to try the case. And I think that you are at a disadvantage trying it against him yourself. And I would urge you to hire an attorney since you don't qualify for a public advocate. I can't make you do that. Do you understand that?
Yes, Judge.
Okay. And, but you do have the right to represent yourself. So if it's still your desire to do that, do you wish to represent yourself?
Judge, I'm looking into a lawyer, but at this time I'd like to settle my motions.
We're going to do that after, but I want to go over this to ensure that we're ready to try the case before you even talk about your motion.
Okay, Judge, I need a lawyer for my trial. I'm not.
I agree.
I'm not neglecting that, but I want my motions settled.
We're going to do your motions, but I'm going to finish this hearing, which we're almost done with.
Yes, Judge.
Okay. So you understand that you may represent yourself, and currently you are representing yourself for these motions.
Yes,
you understand that?
Yes, Judge.
All right. So are you voluntarily representing yourself right now?
Yes, Judge.
All right. I do find that you are knowingly, intelligently, and voluntarily representing yourself. And that, at least for these motions, and you've told me that you want an attorney for the trial, but for these motions anyway, and for the trial, unless you hire an attorney, I do find that you have voluntarily waived your right to counsel, but you may represent yourself at this time. All right, let's start with, there's a motion to change the trial date. It's currently set for April 19th. This was filed by Mr. Newbern. Judge Kaltenbach set that. That's going to be denied. We're going to try the case on April the 19th at 9 a.m.
Judge, if I may briefly address that, I have witnesses that are in training on that day.
I mean, if that was set in court and in the training, according to us in Madisonville, it's an hour away. They can be here for the trial. They can reschedule their training.
Correct.
All right. Start with. I'm going to start with the jury materials and individual voir dire. So, and you've said a number of things in this motion, but what you're asking for is materials provided to potential jurors by mail. Are you requesting the qualification form that they're fill out and send back to us? Is that what you're requesting?
Yes, Judge.
Okay. I will grant that. You are entitled to that, but I'll say this, that under statute 29A-070 of juror qualification forms, you're going to be able to get the panel that you are on, but on sub 7 of that, I'm going to, after reading this, I mean, it's my understanding that there's a lot of recording and posting of this stuff on YouTube. If you want to post me on YouTube, that's fine. I'm a public figure. But the juror qualification forms are not to be posted online. Their name, their address, anything about them. And I am able to limit that. And I'm limiting that to your ability to look at them to prepare for trial. But they're not to be posted online. That is the court order. Is that understood?
Yes, Judge.
Okay. And you understand that if you do post them online, that I could hold you in contempt for doing so.
Yes, Judge.
I'm also going to require you, after you're done with them, after the trial, that you bring them or mail them back to the clerk's office, and they're going to be filed under seal, so that if there's a question about those in the future, they are filed with the court for appellate purposes, so they can look at that.
Judge, I picked them up. Oh, go ahead. Yes, Judge, I understand. Judge, I picked them up at the clerk of courts too.
We'll arrange that for you, so we'll go ahead and arrange to have a panel selected for your trial near the first of the month. Jury orientation is conducted the day is it this month? Probably April 1st or 2nd. It'll be on April 1st. So we'll know the full panel then, but I'll go ahead and request that they make your panels. I'm probably going to need to call in 100 jurors. So let's go ahead and I don't know how many jurors we're going to have. But I'll request that first week of April that they select a panel for your particular trial, since there is apparently some sort of, at least your own media coverage of it. I want to make sure we have enough jurors to seat a jury. So we should have that done by April the 5th. So you'll need to call the clerk's office to speak with Morgan McWhorter. And she can get you that. She can arrange for you to either pick it up or mail it to you. So that resolves that. As far as individual voir dire that is in your request, I mean, that's generally done. It says defendant's request for jury materials and individual voir dire. We're not going to do individual voir dire. We're going to conduct it like a normal trial. I mean, that would be for a death penalty case. So the way that we will conduct voir dire is we'll bring the entire panel in, then we'll select 12 names. They'll come in this box. I will ask them questions at the beginning, such as presumption of innocence. Do they understand that? Right to remain silent. I have no idea if you're going to testify or not. I'll go over the witnesses for Mr. Newbern and for you, if you have them, so that we know if the jury knows anyone that is testifying, so you can have that information. Then we will, I'll ask them other questions that I think are appropriate for this. You'll be sitting in here for it. Then Mr. Newbern will ask them questions. Then you will ask them questions. The other jurors will remain in the back. If jurors are sent home, then another juror will be called up. So that is the way that we'll do it. It won't be individual because I see no reason to do it that way.
Yes, Judge.
Also, you wanted other materials given to the jury. There's a handbook that they're given at orientation. It's available at the clerk's office upstairs, or you can find it online, called We the Jury. Otherwise, they're given that at orientation. They're told about the presumption of innocence, the type of trials that they will possibly sit on, not to do their own research pending that. So I will probably tell them not to. Well, I will tell them not to get online and try to figure out trials that are happening in McCracken County, because we need to be able to seat a jury. They'll be given that book and told when to call in, and they're told that if they are not a citizen of this county, they can't serve. If they don't speak English, they can't serve. If they're a convicted felon, they're currently under indictment. So that is the process. Do you have any questions about that?
That's in We the Jury booklets?
Yeah, I mean,
Okay.
Yeah, I mean, that's essentially in that, but I'm telling you the way that orientation is done as well. And then you'll be able to get the juror qualification forms, with the caveat that you need to keep them private to yourself and your counsel.
Yes, Judge.
All right. Do you have any other questions about that motion?
Request for early jury instructions. The word permission is not anywhere in the law.
Hang on. Are you talking about the jury materials and voir dire, or are you
That's
talking about the
separate.
jury instruction?
That's separate. I'm sorry.
Okay.
No more questions about jury material and voir dire.
Do you have anything on the jury and voir dire?
Judge, one of the issues that was raised was questions about religion. I have no objection to Mr. Heinze asking questions about religion. I think it's appropriate to ask. I will reserve any objections to objectionable questions
At the trial.
raised at the time.
I mean, you were sitting in a church parking lot, so you can ask people about that. But I also want to tell you that you will not argue your case during voir dire. You can ask them questions about why you think that they may be prejudiced by certain beliefs that they have. But you're not going to go on like a talk about religion. Just ask them if they're religious and if they feel a certain way about a church parking lot.
Yes, Judge.
So you'll be required to follow the rules on that. I don't know what you would ask, but you'll be entitled to ask questions. All right. So you want to go over the jury instruction one?
I have a statement to say. The word
Okay. Statement on what?
With the request for jury instructions.
Okay, let me pull that out. So, defendant's early proposed jury instruction, is that what you're referring to?
Yes, Judge.
Okay. So, let me lay the foundation and record first. Mr. Newbern has filed jury instruction, and then you have tendered. Really, the difference is you're looking for a misstatement of law or something like that, if I recall. Jury instruction, mistakes of law by police officers that was proposed by you. I'll tell you this about jury instructions. They're not going to be finalized until the trial is at the time in which we're going to give the instructions to the jury, unless you all agreed on them in advance. So whether or not there would be an instruction that you're asking about mistakes in law by police officers, we're gonna reach that conclusion after the evidence comes in. But generally speaking, if the police, for instance, said that they made a mistake in the law by arresting you, then it probably wouldn't make it to the jury in the first place. So I don't know that that would be necessary. Furthermore, as a general practice of law in this court, we're going to use Cooper's jury instructions because I want to ensure that everything is preserved correctly for appeal. So I have a couple of those that I've already looked at. Mr. Newbern has used some of them. I am contemplating using the one that he gave me and or a different instruction that I found, which slightly differs because it has a caveat that whether or not you knew you were trespassing, that you, in doing so, you knew you did not have such permission, and that notice against trespass on the premises had been posted on the premises in conspicuous manner. And I don't know if that's the case or not, because I don't have that information right now. It hasn't been presented. But I may use that instruction, or I may use the instructions tendered by Mr. Newbern, or I may use your proposed instructions, but I won't know until the evidence comes in, because I don't know what it is. So I cannot tell you what the instructions are going to be, but generally they're going to be Cooper's instructions. And so it's either going to be the one that Mr. Newbern gave me, or the one that I just stated, which is it's either going to be 5.13 of Cooper's or 5.14 of Cooper's. But, of course, you are free to propose your own, and I will consider those, and I'll make a ruling on those so that you would be able to preserve those for appeal. Do you have any other questions about jury instruction?
Yes, Judge. I just want to clear up with this statement, make sure that was covered. The word permission is not anywhere in the law, so the prosecutor's jury instructions cannot be allowed.
Okay. Well, as I stated, as I stated, I'm going to use one of the Cooper's instructions. So, because I don't want to be overturned on appeal by using the wrong jury instructions. So I'm going to use one of the two. And so you can look at both of them, 5.13 and 5.14, and we can determine in the trial on whether or not a parking lot is improved land or not, because you have some issues about whether it's fenced or enclosed, which, from reading through everything, I don't get that it was, but I don't know. And then if it's not, we'll determine whether or not a parking lot is considered improved land. And I'll take arguments on that at the time. But since we haven't taken the evidence yet, we don't have all the facts from testimony, I don't know. So, any other questions about that motion?
No, Judge.
All right, so we'll move on from that. I'm just getting this here so that I don't have
Your comments.
This is all my stuff.
Okay.
All right. We have a defendant's motion for a bill of particulars. Now, the county attorney's office does have an open file discovery policy, and they're required to give that to you because that is their policy. Nonetheless, and you would have that information in the BOP, and you would also have what the offer was in that. Now, Mr. Duggan has responded to your request for a bill of particulars. So as far as that goes, you requested one, he gave you one. Do we need to discuss whether or not he should give you one when he already gave you one?
Just if we could flesh out more of the information.
Okay, what are you specifically requesting?
Well, I first I stand on the bill of particulars, and
Well, he tendered one. So what objection do you have to his tendered
well,
bill of particulars?
I will argue that a bill of particulars is not the same as discovery.
Okay, but nonetheless, whether it is or not, he has complied with your request, which he filed on February the 8th. So unless you have a specific objection to his particular bill of particulars,
It's the argument that there's a divorce between enters or remains, and he did respond.
He did. And that's going to be a question of fact for the jury. They're going to determine whether or not you entered or remained unlawfully or had permission to be there. I mean, they're going to have to make all those determinations.
I seek the essential facts to establish probable cause. He did give his answer, and it sounds short of a requirement for the standard.
Well, I mean, essentially, you were on a church parking lot, which the officer, and I read your transcript. I assume that that's correct, that you attached to your exhibits. They said that you were on a church parking lot and it was private property, and then I believe that Sergeant Burrow said that you're trespassing on the property. I don't know how he knows that. He would have to testify and explain that. I don't know if there's a sign. I don't know if he had talked to the leader of that church, but if in the citation it's at least stated that you were on that property late at night, and that the officer believed that you were trespassing for some reason. So I mean, to me, that's certainly probable cause for criminal trespass third degree. But that's not to say that you're guilty of it. I have no idea. I mean, I presume that you're not guilty because the law requires me to. Those things would have to be presented through witnesses and video and whatever other evidence there is to determine whether or not you did that beyond a reasonable doubt. So that's.
Yes, Judge. I
mean, I don't know what else you want me to say about that.
I have no other questions or statements to make.
So we've covered the bill of particulars here. All right, now. All right, now you have a motion to strike surplusage. So, and then we have a response to that, and then you have a response to that. So, the criminal citation, you are requesting that certain words and or sentences be stricken from that criminal complaint or citation. Then you also state in your legal framework that these may be stricken, and that the facts and allegations are prejudicial if they could leave a jury to base a decision on emotional grounds. That's your number 10 on your legal framework. That's not the uniform citation and or complaint is not evidence. It's not going to come in a trial. It's not. I mean, it's forbidden to do so. So I'm not even going to consider striking words from it since it's not evidence and will not come in a trial. So is there some reason that you want to strike words from something that's inadmissible hearsay?
It sounds like okay, that the court would rely on verbal testimony. I got other
yeah, it would have to be that has never come in a trial because it's not evident. So Mr. Newbern cannot present the citation as evidence of anything. It's disallowed by the rules of evidence. So it is. We don't have to worry about what's in it because the jury will never see it. So, being that your concern is that the jury would be prejudiced by it, and I'm telling you it will never come in as evidence, I'm not going to even consider striking words from it because it's a moot issue.
Yes, Judge.
Okay. Move on from that. Next, you had a motion to grant relief for a defect for prosecution. And so, essentially, what I took out of this is that you're asking me to dismiss this pretrial due to no probable cause in the citation. I mean, I addressed that earlier. That I believe there is probable cause in the citation, but I do not believe there's guilt beyond a reasonable doubt in the citation. That's what the trial would need to be for. And a directed verdict is the proper method of making that request, but that's made at trial. So, do you have anything else to say about that?
No, Judge. No, I don't.
All right. Next, we have. All right. So we did that motion of yours. We did the jury materials of yours. We did. All right. So motion. Have your motion to use a tablet in the courtroom.
I'm asking as I could call it like a third party. It's not exactly. I mean, it's for anybody. I see lawyers who can use their computers and.
I mean, during a trial, you're going to be able to use a computer if you need it. But I'll say this: we're gonna get into this in a minute. As far as recording the proceedings of the trial during the trial, I'm going to get to that in a minute. So the motion to change trial date, I've denied that.
Judge, as far as his motion to use his tablet, I don't have any objection to him using that tablet. So I think he needs to have his arguments with him, and that's fine.
Yeah.
Just as long, I'm not waiving my motion.
Right, I'm going to get to yours in a second. And I agree. I don't have any problem with you using your tablet for the trial. You're certainly entitled to do that, to do whatever legal research and notes that you need. And we're going to discuss recording of that here in just a minute.
Well, I was asking while sitting in the observation area because I need to access my notes even before I stand before the court.
Okay, let's do this. Let's get into the motion to prohibit you from recording court proceedings. All right. So, Mr. Newbern alleges that you have some YouTube channel called Let's Exchange IDs with Travis Heinze with 80,000 subscribers. Okay, that's fine. And if you want to post anything that's recorded on here to that, it's public record. You're free to do so. I'll also grant you copies of anything that is recorded in here for free of charge. So anytime you want to get something that's happened in here today, you're free to get it, and you can put it on YouTube.
Judge, are you saying I could get a CD for free?
Yeah, I'm gonna let you do it because I have concerns if you are recording. So if we have a jury in here, and then you're making your own recordings in court while we're recording it in court, well, these cameras are specially designed to attempt to, the best they can, not have the jury in it all the time. So as you have noticed, I'm sure, they switch when somebody's talking to whoever's talking. And so I have concerns that, it's going to be hard to seat a jury, possibly for this case, maybe more difficult than a normal one, because some of this stuff may come up. And so I want to be able to seat a jury. And so these people are already being called in here, and they don't want to be here. And there are members of the community that have other jobs, and they may be private people, they may be public people, they may want to be on YouTube, they may not. Now, as far as what happens with the recording from the court, if you get that and post it on YouTube, I can't stop that, and, whatever. But what I don't want is you recording them or somebody else, or making other recordings of the trial during the trial, because I feel like it can turn into some problems I can get into them. I mean, I think that there could be some eavesdropping problems where two jurors are talking to each other. You record that. That could be a crime. Potentially, it could be a crime that cross-examination or direct examination is happening, and you're recording it, and you're not talking to it, so you're not a party to that. So, do you have any reason to record the proceedings while we're recording the proceedings?
No, Judge.
Separately? Okay. So you agree that you're not going to record the trial during the trial because you can get a copy of it for free?
Yes, Judge. I promise not to
Okay.
make any recordings in the courtroom.
Okay, that's fine. And you're free to walk around the courthouse and record anything you want, whatever, as long as you're a party to that conversation. But I don't want this court to be a witness to a crime of people recording people that have some sort of reasonable expectation of privacy, such as out in the benches and things like that. I mean, there are cameras and microphones here that don't pick up every spot. So, do you agree to that then, that you're not going to record during the trial your own recording?
Yes, Judge, I agree.
Okay.
I have a question.
Yes.
How can I let the clerk of courts know that CD is free?
Because I'm making an order, and Clerk Alex here will ensure that happens.
I'll be going up.
Yeah, just give him a copy of the CD.
I'll be going up there right after this
Okay,
to
I don't-
request.
Okay.
I won't be able to, for today,
For
I
today.
won't be able to give him a recording of today until tomorrow, because we have afternoon court.
Okay.
So you can pick it up sometime tomorrow. I don't know. What time do you think?
In the morning, he can come in the morning and I'll have it ready for him.
Thank you.
Okay. So you don't have to worry about that. And then the same for the trial. We'll give you a copy of it the next day if you want it. All right. So that, in my mind, resolves the prohibition of court proceedings, because, I mean, unlike federal criminal court and the U.S. Supreme Court, we actually do have cameras here, which I think is a good thing because court is not secret. But nonetheless, I mean, I would prefer that we just use the court cameras.
Yes,
Right.
Judge.
So next, so there's a notice in motion to introduce evidence of prior bad acts pursuant to 404B. So Mr. Newbern says that he wants to present evidence that, and I'm going to paraphrase this, that you have gone to Illinois, Mississippi, Wisconsin, Louisiana, Missouri, and Minnesota, and essentially engaged in similar behavior of, I guess, this, coming into into contact with police and having just a similar chain of events about the ID. And that you are then generating revenue from social media and selling merchandise and things of that nature. My general perspective of this is that I think that a jury would not like that if they thought that you were going around the country essentially setting up the police. Now, I'm not saying that it's illegal what you're doing. And I'm not making any commentary on other states whether or not you have to give somebody your ID or not. Frankly, I don't know what the law is in Illinois, Mississippi, Wisconsin, Louisiana, Missouri, or Minnesota, or a number of other states. But I think that would prejudice the jury, and I think they would be more likely to find you guilty if that was presented. So I'm inclined not to let that evidence in.
Judge, if I may.
You may.
I have a brief argument to that.
Yeah.
Judge, 404B, yes, it is a rule of exclusion with regard to evidence of prior bad acts. However, evidence of that can be presented if it's presented for certain reasons. We're trying to prove, lack of mistake, knowledge on the part of the defendant, common scheme or plan. There's a list of those things. I think that this evidence is important if one of the issues that's going to come up in this case is going to be whether or not Mr. Heinze had actual knowledge that he was not allowed to be on the property. I understand what the court's saying about this being potentially prejudicial, but any type of evidence that would indicate that he committed a crime is prejudicial. The question is whether or not it's unduly prejudicial. I don't think that there's really a showing of that as to this point. I think that really hamstring the Commonwealth from being able to establish certain 404B factors, whether or not he did have knowledge of this. And I think that this is completely probative of his knowledge,
Well,
completely probative of his plan. And
But I mean, the issue is he's not charged with giving officer false identifying information, which would be a crime. He's charged with criminal trespass third degree. So
that's correct.
his crime has nothing to do with whether or not he has, I don't know, engaged in behavior to try to make the police look bad or something like that. I mean, that's not. I guess, for lack of a better word, it's not illegal to be difficult.
That's not the point of him being difficult. The point is that it's probative of his knowledge of going on to places where he is not supposed to be. If you see any of these videos, they almost follow a script. He trespasses. People confront him, and then he goes into this spiel about, let's exchange IDs. I'm not worried about the exchanging of the IDs. I'm worried about the actual trespassing that he's done multiple times across the country. And I'm not going to present an exhaustive list, but I think it's fair, first of all, for us to be able to ask the officers if that's what he did. If he started recording this when he was encountered. The second thing, I think that we at least need to be able to ask about this during voir dire.
Well,
I don't think that if I'm not allowed to mention this in any way, again, I don't think that.
Well, I didn't say that you couldn't mention the fact that he was asked for his ID, and then, at least according to the transcript provided by Mr. Heinze asked for the officer's ID, and then another officer asked Mr. Heinze for an ID, and then he asked that officer for an ID. I mean, I didn't say that you couldn't talk about that. That's on the video. I'm not saying that you can't present your case. I'm just saying that, so all these, I don't know what the criminal trespass statutes are in those other states. I don't know what happened with the cases. And I don't think that proves whether or not he entered or unlawfully remained or whatever the other prong of that is without, notice that he knew he was trespassing, essentially. I don't know that proves that. Because
I think it's probative.
Well, I don't know. I mean, I don't know if he was in a Walmart parking lot in the other ones. I don't know if he was. What if there was a sign on this one but not another one that said no trespassing? I don't know any of those things, and I don't think that the fact that he engages in this let's exchange IDs thing with the police. That doesn't prove whether or not he was trespassing. The fact that he engages in that course of conduct.
Judge, again, I don't think for 404B that I have to establish that it proves that he did anything. I think again, it's probative of those factors.
I'm not saying it's not, but I think it's highly prejudicial in that if a jury sees this thing where, if they think he's a person that engages in an activity that is not illegal, but it's kind of a gotcha to the police thing, I don't think they would like that. And I think they would be more likely to find him guilty because of that.
Well, Judge, I don't think that
But you're going to be able to present your evidence of him doing that here. So they can look at that however they want.
That's correct, Judge. Again,
Right.
But one of the things that I know is going to come up in this trial is that I didn't have knowledge. That's going to be one of the first things.
If Mr. Heinze were to testify that, then he would open the door to his prior bad acts. So, in your case in chief, I'm not going to allow you to present that. But if Mr. Heinze decides to testify and say that he has no idea what was going on, then he could open the door to his prior bad acts by whatever statements he made. And I'm not going to say what the magic words would be because I don't know. But he could certainly open the door to it, saying that I've never been in trouble like this before. This has never happened to me. If he said something like that, then all of it would come in. But
Okay, so just so that I understand the court's ruling.
Your case in chief,
if he opens the door,
if he testifies and opens the door, now you're going to have to approach, and we're going to have to discuss the legalities of it and whether or not I believe that he's opened the door. Then you could introduce that evidence through cross-examination.
Okay, I just want to make sure that I'm clear on that ruling.
Yeah.
Thank you.
But I mean, that's any case with 404B. I mean, somebody can always open the door. So do you understand what I'm saying?
Yes, Judge. In presenting a criminal history compared to a YouTube history, I wouldn't have to open a door for criminal history, right? It would be just an open.
He's not going to be able to say that you did this in 7 other states unless you did something to allow that. Like, he's not going to be able to do that in his case in chief. Now, if you testified and said something that could change that ruling, that's possible. But in his case in chief, I'm not going to allow him to present the 404B evidence of prior acts of this nature.
Yes, Judge. It sounds like it hinges on testifying. If I testify,
Or somebody else. I mean, I don't know. Like, but it would be you, in your case that it could be, the door could be open. But that's any criminal case that anyone wants to present prior bad acts. It would be like if you had a history of domestic violence, I would not allow the history of violence to come in the case in chief. But if somebody got up here and testified and said, I've never hit anyone before, then all that stuff would come in. So that's the simplest way that I can put the way it would work.
And if he opens the door on cross-examination?
Yeah, it's possible, but it's more difficult.
If he does, I'm just asking if I have the ability to approach.
You can approach. You can approach any time if you believe that he's opened the door.
Just want to make sure.
and if I asked what the officer's prior knowledge of the YouTube situation was before they approached me, I mean, that would just
I mean,
establish something.
I don't know. I mean, I can't give you legal advice on it.
Yes, Your Honor.
Okay, so my ruling officially on the 404B prior bad acts is the Commonwealth cannot present that in their case in chief of the prior bad acts, but it is possible that it comes in if the door is open by your waiver of that. So, which I can't give you legal advice on, but I can tell you if he presents it and you don't say anything, it would never come in. But I'm not telling you that you shouldn't do that. I don't know what your trial strategy is. All right. So do we have any other motion?
He had a motion, I believe, to compel evidence, Judge, and
Okay.
that was the last one.
Where is that? Do you have a copy of it, Mr. Goodman?
Here it is.
Yes, I did.
Motion number 2. What particular evidence are you requesting?
Emails, Judge, the emails that have been redacted with the white space. I'd like to see the.
Are they
full-
this exhibit here with like 5 or 6 emails?
Yes, Judge, about 8 emails that are claimed to have come from the church, but the wording doesn't indicate so.
Judge, these are emails, internal emails from the Sheriff's Department.
From the church to the sheriff's department?
No, they're internal,
Okay.
between members of the Sheriff's Office.
All right. And that's this listed as Exhibit 1. Whose exhibit is this?
What does that say?
It's your exhibit? So you're wanting these emails?
I request the full email. See, it's hard to tell. They're white space redactions, so it's hard to say. Unlike black space redactions, which makes it obvious to notice, they're white space. So I believe there's two sets. One kind of the original, then the next showing the redacted.
Right. So, I mean, one of these, the first one that I see any kind of redaction in, involves a juvenile. So, I mean, obviously, we're not going to give you the juvenile's name. So you want them to be redacted with black marker rather than white?
I don't want them redacted at all, Judge.
Okay. Well, why do you need this 17-year-old's name?
I don't want the 17-year-old's name, Judge.
Okay. So what?
In the from category, there is a white space. It's
Okay, you're talking about the top
yes, Judge.
of the email. You want to know who sent the email?
I want to know that, Judge, and also there's some messages not with the 17-year-old, but other information that's white space redacted. I don't believe is
Okay.
they're not all.
I mean, one of these is like a domestic violence situation. I mean, do you want those people's names? I mean, I don't see why.
I mean, I don't need to see victims' names.
Right.
It's what's most important. The higher priority is to see where they're sent from.
So you want to know who sent the email?
Yes, Judge.
What's your position on that?
Judge, my position is that, and as I make this plain the last quarter periods, I don't mind giving him the names of the people on those emails, but I don't want to give him email addresses. The problem that came up is that the sheriff's department, the county attorney's office, and the church, they have been flooded with phone calls from people ostensibly who follow Mr. Heinze's YouTube channel. And it's harassment. It's harassment, so I don't want to give out an email address and give license to that. I'll be more than happy to give him the names.
So does the name appear as the name or the sheriff's here? So on these emails, does the name appear as the email address or as the?
Typically, sir, on our emails, it would be the name.
So it won't. Their email address won't be shown.
I think it does, Judge.
It does.
I would say the ones that you're talking about, sir.
So, and we're talking about Mr. Heinze, and I want to be correct that you're not asking for victims' names, correct? Because
I do not.
I mean, yeah, I don't see any reason to. All right, so, like on the from, is it going to show up as somebody's email address?
I would assume that one will be a name on Exhibit 1.
So,
The other question that I would have, Judge, is actually what is the relevance of that?
well, if you've already said that you are okay with the names,
I'm just asking what the relevance of the email.
what do you need the names for?
It gives me more context to know who is sent because prosecutor Cade or Mr. Foster had said that it came from the church, and now I'm being told that it's internal from the sheriff's department, and the language speaks that in a way that it sounds like it's language with the communication within the sheriff's department.
And Judge, if there was ever a situation where we said that it came from the church, that was a mistake.
So these are
One
internal
thing I
sheriff's
read
department.
these emails and tell that they are internal emails from the sheriff's department. I mean, it's not a situation where, I mean, this was malicious on the part of the county attorney's office.
The white space doesn't is easy to skip over. I found it wasn't even me who discovered this. It was somebody else. The white space redacted. If it could be black space, which is pretty typical, then you would know what's redacted. But white space, seems sneaky.
How so?
I skipped over it. I just by my own mistake of overlooking the email, thinking that it was complete and whole.
So you think that you were trying to be sneaky with you? Is that what it is?
It felt like it
Why is that?
because I just didn't know. I didn't see
What do you need to know from the
the
email?
missing. What?
What do you need to know from the email?
I want to know. Well, clarification. I want to clarify in its full entirety without victims added. Want to know it. I'm asking for full evidence. I mean,
Okay, so you're asking for the name of the people who sent the email, but you don't need their email address to email them, do you?
I don't need to email them, Judge.
All right. So, I mean, and I see no reason to give you victim names because there's no reason for that. I mean, unless you can tell me a compelling reason to give you that.
No compelling reason to.
All right.
But for potential calling as a witness, I'd like to know who wrote the source of this
Judge,
of this evidence.
if I may really briefly.
Go ahead.
So early on at Mr. Heinze's first run, there was some back and forth about whether the church had requested assistance with trespassers.
Okay.
During initial discovery, I thought we had some emails from the church. And I told Mr. Heinze we had some emails from SBT Church. That's what his transcript says. I haven't reviewed the record, but he says I said it. I'll take it on good faith that I might have said that. The emails, but it wasn't an evidentiary hearing. I don't feel like I have any issues with candor in the court because I was just talking to opposing counsel essentially. We provided those emails. They are 100% internal. The only way, and I'll tell Mr. Heinze this, the only way the sheriff's office had knowledge was phone calls. We don't have recordings of those, we don't have record of those. But the emails that are 100% internal, we do not plan on introducing those at trial. It seems like a moot issue, but
Well, being that he has the emails, I'll at least allow him to know the names of the people who sent them. So that if he wanted to subpoena one of those people for trial, he could. I don't know if it would be relevant. I don't know if I'd let the testimony in. It may not be relevant, but
how should we address that? If it is just an email address, but we can.
Just write the person's name, who it is, from the sheriff's department.
Is he going to believe us if we do that, Judge? I mean, how are we going to get into this? Because he might say, "Oh, they're fabricating evidence."
Well, I mean, the sheriff is here. Do you have any problem with the sheriff writing the names of his employees that are on there?
Well, I mean, more ideally to have it in its photocopy original form. I mean, maybe he could sign off. The sheriff could, if he could write the names and then sign off that he attests that this is like an affidavit, make an affidavit saying that this is, these are the names.
I could just swear him in and ask if he can put the names on there under oath. And then, are you willing to do that?
Yes, sir.
If you can, just come wherever you want where a camera's going to pick you up. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give you the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right. I have a list of exhibits here, email addresses that I have been told were internal emails between members of the sheriff's department. Is that correct?
Yes, sir.
And did I show those to you here just a few minutes ago?
Yes, sir. You
There
did.
are 1, 2, 3, 4, 5, 6, 7, 8 of them. Do you hereby swear that you will? I mean, we've agreed that Mr. Heinze does not need their email address, but that you will write their correct name on there.
Yes, sir. I will.
So, does that satisfy you?
Yes, sir. Yes, Judge, that's satisfying. And when may I receive them?
I mean, how long will it take you to do that?
I will have to obtain them from the county attorney's office. I probably have it done this morning.
Tomorrow. I mean, he's going to get a copy of the tape tomorrow. Can you have it by tomorrow morning?
Yes, sir.
All right. So that resolves that issue.
Yes, Judge. The talk about harassments. I mean, I don't know how relevant that is for the trial.
And what's
But I mean,
At the trial.
okay, I just then that harassment argument was made for the emails specifically.
You're not charged with harassment.
Okay, all right, because I was okay. Yes, Judge.
I'm not saying that a crime could not be committed in the future or has been that I don't know about, but
Because I would ask for evidence if we're going to talk about harassment.
you're not
just-
charged. You're not charged with it, so we're not going to talk about it.
Yes, Judge.
So that is what you wanted as far as compelling evidence, correct?
And let's see.
And also, if you want to subpoena anyone to the trial, Mr. Heinze, you can go upstairs and obtain subpoenas from the clerk's office.
Yes, Judge. I'm trying to. I mean, it'd be. This is kind of opinionated. It'd be more. It'd be a better process, easier process for me if everything went through the prosecutor. But in a way, I'm compelling the training and discipline records of the police through another means. I guess directly through the.
I mean, if they don't have that in their possession, I can't order them to give it to you.
Judge, they have him here today, but he's essentially emailing us what he wants, and inferring that we should be the ones to go get his evidence, and we don't represent him. I told him that.
So the prosecutor's office, they're required to give you whatever that they have pertaining to your case. But if they don't have something in their possession, they're not required to give it to you because they don't possess it. So you need to subpoena those items to a court date. But nonetheless, Mr. Foster, so he sent you a request for something?
He did a long time ago, and we told him, I think Mr. Newbern told him, if I'm correct, that, you need to subpoena it, okay? And it's disciplinary records, and training records from the POPs file. Sheriff's has them today to enter in the court record and give Mr. Heinze a call.
So apparently they're going to give you a copy of it today. Sheriff is.
Yes, Judge. And I'm also asking the policies, and I'm told I should go through the court.
Whose policies?
The sheriff policies, there's,
You're going to have to get that from the sheriff's department. I don't have any authority over the sheriff's department.
okay, yes, Judge.
And I can't give you legal advice on how to get it, but I can tell you, you have a trial set. You can subpoena things to the trial. There are certain procedures that you have to follow when subpoenaing items that have to be subpoenaed to a court date.
Yes.
So you're going to be required to follow those laws.
Yes, Judge. When I subpoena the training records, it was for I set a date for today. But if I subpoena for the policies, it asks for court dates in there.
You're asking for their policy and procedure manual. You want to subpoena that to a court
Yes,
date?
Judge. I mean, it seems to be becoming more difficult
I mean-
to see.
I mean, like I said, I can't. If they don't have something, everyone's their own independent office, and then I'm like the referee between all of it, but I don't possess any of their things. And then the prosecutor's office doesn't possess the materials of the sheriff's department unless they're given the materials of a specific case. Just like the clerk's office operates separately, and the public defender's office operates separate entities. So I can resolve discovery disputes, but if they don't have it and they're telling me they don't have it, they're licensed attorneys, and they're required to be candid to me about it. So the sheriff's department has it apparently, and they are going to give you something today.
Yes, Judge. And I also, once I get the policies, I have to set put a court date in the
You need a subpoena return date.
Should I? What court date would I?
I can give you next Thursday as just a subpoena return date,
Oh,
but
yes.
we're not. But it's not going to be a large hearing on motions for the trial. It's just to subpoena whatever items you need. And so the reason there's a subpoena return date is so you and the prosecutor both get copies of whatever is subpoenaed to court. So nobody can keep a secret from somebody else.
Yes, Judge. Thank you.
Okay. So do you want a subpoena return date for next Thursday?
Well, I intend to make a subpoena for the policies. So I would
So
ask.
you want a
I would
subpoena
ask,
return
yes,
date?
yes, Judge. I would ask for a date, and then I would make the subpoena, and then fill it out for that date.
I'll give you a subpoena return date for March 21st at 9 a.m. And so let me tell you what we're going to do on that date. I'm going to call it. You're going to tell me who you subpoenaed. We're going to call their name. Everyone's going to get a copy of it, and that's going to be the essence of the hearing. We're not going to have a long discussion about it.
Yes, Judge. Unless I receive the policies before that,
Well,
then maybe we could.
it's because you're required to subpoena it to court unless the sheriff's department wants to give it to you. Any opinion on that, Sheriff?
Sir, I believe it should,
You want him to
county
subpoena it to court?
attorney's office maybe different, but I believe that that's probably the best procedure.
All right, so subpoena it to court, and then we'll see you. I will set a subpoena return date for March 21st. If you wish to subpoena something to that date, you may, but you don't have to.
You'll call it, and if I'm not here,
Then,
it'll just be skipped over.
right.
Yes, Judge.
You're not going to be, the subpoena return date, if you choose not to subpoena anything, you don't have to be here for it. You're not going to get arrested for it or get a bench warrant. So it's just a date and that's for them too. If they want to subpoena something, then they can.
Do we need to have all our witnesses subpoenaed by that date? Is that what you're saying, or is it just?
No, it's a subpoena return date for
Cool.
documents,
Records,
for records,
okay.
documents, anything discovery.
Okay.
That is because, this trial is scheduled for April 19th,
Yes, sir.
and we're going to try it on April 19th.
You are. Yes, sir.
So,
Excellent. Great.
and other than that subpoena return date, this is the last court date for it.
Judge, I saw something. There was something 2 days before the trial date. Some kind of
What, do
hearing.
you need a hearing 2 days before the court date?
Okay, I thought I saw it on the computer or something that's scheduled, just kind of a
A pretrial
Pre-
conference? Well, I mean, we can have it or not have it. I mean, if you're ready to go on trial, then we don't need it. But if you want that court date, I'll keep it. But if I keep it, you have to come to it. So it's up to you.
I'm just making a comment that I
Yeah.
saw it on the computer. I wasn't sure to think about it, to think of.
I mean, since Judge Kaltenbeck said it, I had the flu on that day, so I don't know. All I know is what I read on the docket. So, do you want the pretrial conference 2 days prior to the trial?
Yes, Judge?
Okay, that's fine. I mean, that's not abnormal to have that. But if this case is going to be resolved, today is the day to do it. Whether on the 17th, we're just making sure that everybody has their documents or whatever that they need. But if there's a resolution, it's today because we're not going to. I'm going to use that trial date for something else if you don't want it. So today's the day. So I don't know if you want to resolve it or not. It's up to you and them. But I'm ready to go on April 19th. And then you're telling me that there's also a court date for April. It's probably the 18th or 16th. What day is it?
It's the 16th.
Okay, April 16th at 9 a.m. And that shouldn't take long. It's just is everybody ready to go?
Yes, Judge. Is there a reasonable period of time for subpoenas that the court considers a reasonable period of time for notification before
For the trial? Like subpoena a witness?
For a subpoena return date? What?
Well, they have to have notice to appear at the court date, right?
Yes, Judge. March 21st. So if
So a week from
what
today.
would the court consider a reasonable period of time, like a week in advance?
Well, I mean, we're a week out right now, so
Judge, I think he's trying to get at what witnesses we plan to call to trial, and he's worried that we're gonna try and slide some evidence in at the last minute, so he's asking
Well,
what is
if
a
they-
reasonable amount of time that we
So-
can bring in new evidence.
I mean, for each of you, it's just whenever somebody gets subpoenaed. I mean, there sometimes for reasons unknown, somebody doesn't get subpoenaed until the day before trial because nobody knows where they are. Could work. That could be you or them. I don't know. I mean, I don't get involved in that part. It's just somebody has to make a subpoena, and that person has to be served for that court date. So, however that works, and then if that person doesn't appear, and then I mean, there's also the caveat of somebody can appear without a subpoena if they want to, but it would be foolish to do that because, I mean, I can hold somebody responsible for not appearing if they're subpoenaed. So, I would imagine that would not happen with them anyway. I don't know. So is that what you're asking me? Like how quickly, how much?
I'm satisfied with
Okay, so
questioning.
clear. Okay. Anything else?
I don't believe I have anything else to
Okay. So,
say.
so to be clear, this court has ruled on all Mr. Heinze and Mr. Newbern's motions, other than possible subpoena return date and a pretrial conference, which is on April 16th, and the subpoena return date for document production on March the 14th. We've resolved all issues.
What, Judge, one more thing. The sheriff said that he had to go through the court to hand me the training records
Okay.
somehow.
Do you have those training records?
Yes, sir.
Okay. Can you present those to Mr. Heinze?
Yes, sir.
Do you have copies for the county attorney's office?
I do, sir.
All right. So
Judge, I think he has a copy for the court record.
okay.
We had 3 copies,
I
Sheriff.
have 2 copies.
2 copies, but the second copy going to the court record.
Well,
for the record.
you keep the second copy, unless it's introduced in evidence. I don't need it for the court record. All right. So this court has also conducted a Faretta hearing with Mr. Heinze, and I believe Mr. Heinze is aware of his risks at trial, which are maximum fine of $100 plus court costs, which are another $220. $320. So if you were found guilty, the maximum penalty you would receive is $320, including court costs. Also, we've gone over your knowledge of the law, the rules of evidence that I believe that you should hire an attorney, but you're free to represent yourself. I believe that you understand what you're getting into, and what the maximum penalties are and what you're up against with Mr. Newbern. Though you do not have an attorney, you're free to hire an attorney at any time. But if you're hiring an attorney, we're trying that case on April 19th.
Okay, just
So-
for clarification, you're saying if I tried to hire one a day before the
We're
trial,
having
on
on
the,
April 19th.
we're still, yeah, he would
I would
have,
make them do it too. If they came on April 19th and said, Mr. Newbern took a different job and we're not ready to go, I'd say, Mr. Foster, have a seat. You're trying. So, it's going to go like that for both of you. Okay?
yes, Judge.
All right. Any other business before the court?
Nothing much, Judge.
No, Judge.
Court is adjourned.
Thank you.